Hi everyone, good afternoon and a very warm welcome to Thorough Newspaper Analysis. Today is 25th of May and this entire video series is brought to you by LawSikho. Now as far as the agenda for today is concerned, first we have the editorial segment. So here we have two articles for our discussion. We're going to take up this one as the first article, which is titled as Legal Questions in Narco Tests. See, here we talk about the legality governing a narco test. We have a look at some of the important judgments in this regard, the guidelines that were laid down, and all of this is in light of a recent development in the ongoing protest by the wrestlers of our nation. Secondly, we talk about the committee report in the matter of Adani and Heidenberg fiasco and how the author feels that this report it is incomplete. Second segment for today's discussion is the news update segment. And thirdly, we talk about the important legal development of the day. So with this, let's start off with the TNA. And first, we cater to this article, which is titled as Legal Questions in Narco Tests. This is going to be our order of understanding of it. So first, we talk about the issue at hand. Then we have a look at what a narco test is. How is it different from a polygraph test? Thirdly, we talk about the legality of such tests. So for this purpose, we go back to 2006 Madras High Court, then we come to Delhi High Court. Thirdly, we talk about the Supreme Court landmark judgment, and then we look at the recent development. And fourthly, an important segment is the evidentiary value of this sort of a test. This is, in fact, a very critical facet of this entire discussion. So let's understand the why of this article. See, on Monday, the protesting wrestlers they've come forward to say that they're ready to take a narco analysis test for the purpose of showing that they are speaking the truth and the allegations that they've leveled against the president of the Wrestling Federation of India, Brij Bhushan Singh. These allegations, these are not false claims. These are, in fact, the truth that they're speaking. Now, this is in light of the claim that was made by Brij Bhushan Singh, who said that he was willing to take a narco analysis test or a lie detector test if the wrestlers agree to take this. The wrestlers, however, also put a condition. They've said that they were willing to undertake a test provided the Honorable Supreme Court monitors this entire process and that the result they be made public. Now let's understand as to what essentially a narco test is. See, narco test here, what happens is a drug is injected in the body of an accused person, and this drug it essentially transports the accused into a hypnotic or a sedated sort of a state. So here his imagination capabilities they are neutralized, thereby it helps in divergence of an information which is nothing but the truth. On the other hand, a polygraph test is also aimed at addressing or bringing forth or diverging truth, but it operates in a slightly different manner. So here it operates on the assumption that the physiological responses which are triggered when one person is lying, it is different from when he is acting otherwise. And here we don't make use of any drug which is administered. Rather, we make use of certain appliances or instruments for the purpose of keeping a tap at certain variables of the body of the person, like the activities of the sweat glands, the blood pressure, the pulse rate, the respiration, how it changes when the person is being questioned in the test. So this is how a polygraph test operates. Now let's understand the legality of such sort of a test. So see, for this purpose, first we go back to the Madras High Court in the year 2006, when in the case of Dinesh Dalmia versus the state, the High Court observed that since the accused did not come forward with the truth, therefore the scientific test it did not amount to testimonial compulsions. And also interestingly, the High Court stated that since there's a lot of hue and cry among the public and the human rights activists that often the investigating agencies they make use of third degree methods for the purpose of extracting confessions and other investigating modalities. So therefore the court said that scientific tests these can be made use of by the investigating agencies for the purpose of better investigation. Secondly, we come to the Delhi High Court in the year 2006 in the case of Shri Shailendra Sharma and versus the state in another. So here the Delhi High Court said that in light of the rising crime rates, it is necessary to conduct thorough investigation while respecting the constitutional rights of the accused, and for the purpose of ensuring this robust or thorough investigation mechanism, we can make use of the scientific methods of investigation. And then we come to the landmark judgment of Selvi and others versus State of Karnataka and another, wherein the Supreme Court it mandated that for the purpose of making an accused undergo such sort of scientific test, the lie detector test, there has to be a consent of the person concerned, and without consent, you cannot ask the person to undergo such sort of a test. And also, the court said that the court gave certain safeguards to the person who consents. So the court said that such a person or accused should be made available or made accessible to a lawyer, and also all the ramification of undergoing such a test, the physical, mental, emotional, they should be made understandable to the accused person by the lawyer and by the police officers concerned. Also, the court emphasized that the guidelines for administration of polygraph test on accused which were essentially laid down by the National Human Rights Commission in the year 2000, these were strictly followed. See here in these guidelines as well, the same was held or suggested by the Human Rights Commission. The consent of the accused person must be there, and also that the consent must be recorded before the magistrate before you conduct a lie detector test. And now let's understand post 2010 developments. So for this purpose, first we have the 2013 Arushi Talwar murder case update. So here the parents of Arushi Talwar, they approached the Honorable Apex Court and they demanded narco test of 3 persons who were initially made the accused. The court, however, dismissed this petition on the ground that this was leak because the matter was already at the final stage of the hearing. Now, secondly, we have a 2019 update wherein the entire fraud which was committed by the absconding dwellers Nirav Modi and Mehul Choksi, it came to the forefront. So the CBI wanted to conduct narco test of a former staff member of the Punjab National Bank, and for this purpose, the relevant applications were made. However, the person concerned, he did not consent to undergo the very last year itself, a Delhi court, it allowed narco test of Aftab Punewala, who was accused or is an accused in the killing of his live-in partner Shraddha Walker. Punewala, he said that he consented to the test. He understands very well the consequences of the test involved. Now let's understand a critical aspect of what is the evidentiary value of such sort of a test. So see, the results of narco test, firstly, we need to understand that they are not considered as because those in a drug induced state, they cannot exercise their choice, of course, because they are under the influence of the drug, so they cannot be deemed to give answers or information out of their own choice by virtue of their cognitive faculties. But the Supreme Court, in its 2010 Selvi's judgment or ruling, it categorically clarified that any information or material that is subsequently discovered with the help of the voluntary administered test results, that it can be admitted in accordance with the section 27 of the Indian Evidence Act. So with this, let's understand the next article for today, which is titled as Incomplete Conclusions. See here, what essentially happened was, in the very beginning of this year itself, we had the Heidenberg report. So post this report, the Supreme Court was approached with a batch of petitions in the month of March, wherein the petitioners were claiming that report, the share prices of the Adani Group company, it declined. So the Supreme Court, as a result, issued certain orders, and the bench it for, issued orders with for the purpose of formation of a committee, which was to be headed by a Supreme Court judge, and this was to inquire into the Adani Heidenberg tussle. Now this committee, it now has published, or it now has submitted its report, and the matter has been kept for consideration month of July for this year. And this committee was to look into particularly matters with respect to security law breaches, failure of regulations, and non-disclosure of related party transactions. Now, the author of this article, who is a practicing advocate in the Honorable Apex Court of India, Supreme Court, he has certain issues with this report and he has highlighted those issues in this article. As far as the first issue, which is highlighted by the author, is concerned, He has said that it has exonerated SEBI, which is the market regulator, the securities regulator. It has exonerated it and it has left it to SEBI to investigate the matter further. So, by virtue of this, by failing to dig deeper into SEBI's course of action, the committee falls short of its task. This is what the author is proposing. Secondly, the author is saying that agencies like the Central Board of Direct Taxes and the Enforcement Directorate, they've no breaches in law. So while the same, it is a welcome news for the market regulator. As per the author, it does not aid to the loss that is suffered by the stakeholders. Now, why this report is problematic is because it creates an undisputable pickle since SEBI, in its response to the claims which are made by the committee, it has stated that there is an inability on part of SEBI to carry forward the investigation because of absence of information. Author is essentially saying that this is a classic example of the question, never-ending question of what came first, the egg or the chicken. Now, there is also a marked absence of the serious fraud investigation office's involvement here in this matter because it has expansive powers to look into corporate misgovernance and fraud, but it has not come to aid in this matter. And had it been involved, then the matter would have been more transparent as per the author. Failure to address issues head on, it leaves much to imagination. The concerns of the investors too are not adequately answered. Now, with this, let's advance to the next segment for today. And now we proceed to the national news category for today. Prime Minister Narendra Modi and his Australian counterpart, they've renamed Sydney suburb as Little India. Harris Park, it is a hub in Western Sydney where the Indian community celebrates the festivals and events such as Diwali and Australia Day. This announcement to declare Harris Park as Little India, it was made by the Australian Prime Minister Anthony Albanese while he welcomed the Prime Minister of India at the community event. The first proposal for officially naming the area as Little India, it was made in the year 2015. Tata Group, it is the only Indian firm to feature in the list of top 50 most innovative firms across the world. Boston Consulting Group, it has released a report of the top 50 companies in the year 2023. These companies are the most innovative in their operations. The group has highlighted that the most innovative companies, they were generating greater financial rewards for their shareholders. A global survey which was conducted by the group, it has highlighted the benefits of innovation and how measures such as mergers and acquisitions, portfolio planning, technology like AI, they were essentially helping companies to innovate way past their competitors. As far as India is concerned, Tata Group, it is the only Indian company to feature in the list. Now we have an update in the world of sports. So the city of Chennai, it is all set to host Squash World Cup in the month of June. 8 countries, including India, they are going to be the participants in this particular tournament. These countries are Hong Kong, Japan, Malaysia, Egypt, Australia, South Africa, and Colombia. The last edition of the World Cup, it was held in Chennai in the year 2011, and this is going to be the fourth edition. It is also particularly notable for gender parity and for the point system. Garden Reach Shipbuilders and Engineers Limited, it has embarked on a mission to identify and to encourage the development of innovative solutions towards technological advances in the shipbuilding industry by startups. As part of this drive, GAINS 2023, it was launched at Calcutta. GAINS stand for Accelerated Innovation Nurturing Scheme. This was launched to leverage the ecosystem that addresses the present as well as the emerging challenges in the ship design and the construction industry. The GAINS 2023 challenge, it is a two-stage process for the purpose of helping in generation of a large number of ideas from which a few promising ones are going to be picked and selected and further nurtured. Veteran actor Sarath Babu, he has passed away at the age of 71 in Hyderabad. He was a prominent figure when it comes to the Tamil and the Telugu cinema. He first acted in a movie in the year 1973 and started his career in the movie called Rama Rajam, and he rose to fame in the movie which was called Patina Pravesam. This was in 1977. Apart from this, he was also a prominent figure in Malayalam films as well as in Kannada films. The list of some of these films are given here on your screens. Next, we have an update with respect to Indian Commonwealth Day, which was observed on 24th of May. The theme for this year's Commonwealth Day is Forging a Sustainable and Peaceful Common Future, commonly known as the Empire Day. This occasion, it is aimed at bringing together 2.5 billion citizens of the Commonwealth for the purpose of recognizing their common value systems. It is also this particular date also emphasizes the importance of working together towards a sustainable and peaceful future for all. Commonwealth Day, it is worldwide celebrated on 13th of March. However, in India and certain other countries, it is celebrated on or observed on 24th of May. The Education Ministry, it is called for first meeting which is aimed at unifying 60 school boards which are operating in different states of India as well as in union territories. So the workshop, it is going to study the school assessments, examination practices and equivalence of boards across the country. The main component of this program or plan, it is Parak or the National Assessment Center, which have been set up as an organization under the NCRT. The mandate of Parak, it is to work on bringing the school boards across the states and the union territories to a common platform. Sourav Ganguly, he is the brand ambassador of Tripura Tourism. After a brief discussion with the tourism minister, the former Indian skipper, he said that he is almost ready to take over the job of the tourism brand ambassador, and he said that he is going to visit the northeastern state as and when he is called upon to do so. The state government of Tripura, it has been keen in developing the tourism industry, and it has been investing in a series of novel tourism initiatives such as modernize ecotourism or tea tourism, and the state has also ramped up its religious tourism sites through the Prasad or and the Swadesh Darshan schemes. And this has brought us to the last segment for today, which is the segment of legal updates. The Delhi High Court has recently held or ruled that lawyers who are appearing on the criminal side of an accused or the prosecution, they cannot claim a right to own arms license. Why? Because it could result in issuance of such licenses indiscriminately. The court further observed that the arms license, this is a creation of the Arms Act of 1959, and the licensing authority, it enjoys the discretion whether license is to be granted or not, depending on the facts and situations of each case. The name of this particular case is Advocate Shiv Kumar versus Union of India and others. And with this, we've come to an end for the TNA. In case you want to get access to the free study material that LawSikho curates or the TNA slides that were used in this video, I would highly encourage all of you to visit our Telegram channel and join the same. For the same purpose, you may scan the barcode here or you may click on the link which is given in the description. These are the point of contacts in case you want to get in touch with LawSikho. Thank you for being with us.